All right. We are here to hear oral arguments on State of Ohio versus Devon Williams. Each side has 15 minutes to present its arguments. Those rules don't change. The appellant may reserve up to 5 minutes for rebuttal. Mr. James, if you wish to reserve time, let me know before you start your argument. These arguments are being visually and audibly recorded to be posted online, so keep your voices up, although because we're doing it this way, I guess you don't need to scream. We can hear you fine. I won't caution you about using the names of children because that's not applicable in this case, but of course don't use the names of victims. We have read your briefs and are ready to proceed. The one thing I would like to ask is that whoever is not speaking, if you would go ahead and mute your mic, and I guess Attorney Corrigan, that'd be you right now, so that Mr. James can go ahead and proceed. So Mr. James, whenever you're ready, we are.
Thank you very much, Your Honor. I appreciate that. And I would reserve 3 minutes in rebuttal. I'm not sure I'll need it, but let's go with 3 minutes.
All right.
All right. Proceed, Your Honor.
Please do.
Thank you very much. Good morning, Your Honors. I am Jeff James. I was appointed to represent Devon Williams in this appeal. This is an appeal from his conviction for murder, along with felonious assault and gun specifications and carrying a concealed weapon. He's currently serving time on those sentences. I won't go through the detail. This is not a complex case, and I think that's kind of important, but it is fact intensive. And that's why it was important, I think, to have the court review this. It was also important, and I think the family, Devon Williams, in talking with all of them, they surely wanted to make sure that this matter proceeded to oral argument so that the panel would understand the importance of the facts in this case. This is, and the only assignment of error that I did raise was a manifest weight argument. Basically, when a manifest weight argument is presented, it is a de novo review by the full panel. And the question is very simple, is did the jury clearly lose its way in reaching its verdict?
Mr. James, before you go
Yes.
further, can I ask you a question just about the manifest weight issue? I've been scratching my head over this because I know both sides have agreed that the new, not so new anymore, but new self-defense applies. And part of your argument, or the bulk of your argument, was that the state didn't prove beyond a reasonable doubt, because that burden is now shifted to the state. Is proof beyond a reasonable doubt or lack thereof a manifest weight argument?
Yeah, I don't think there's any question, but that's exactly what it is. I mean, a manifest weight argument raises the issue that the panel must review the facts in total and determine in the old, understand prior to the enactment of 2901.05B1, where we shifted the burden, it was the same thing. The jury, or you of the panel, would look at the totality of the facts and determine, did the state prove beyond a reasonable doubt each and every element of the offense sufficient to sustain the jury verdict? What is now kind of an added piece to that with the shift is that now you must also look at it and say, did the state prove in this case, based upon their burden beyond a reasonable doubt, did they prove that the defendant did not act in self-defense? So I do believe that it requires, it's the same standard applied two different ways.
Okay, thank you.
Okay. And with that being said, I believe this may be the first case that came to trial in Summit County under the new self-defense shifting of the burden under 2901.05. Why I say this is a fact-intensive case is that, first off, a manifest weight argument always is fact-intensive. That's really what we're asking the panel to do, is look at the facts, the totality of the record in this case, and make a decision, did the jury clearly lose its way? What we know in this case is that, and I'll simply refer to him as SP, as the alleged victim in this case, is that SP and Devon Williams had an ongoing dispute. There was no, in the record, it is clear that they had at least 3 prior altercations prior to the incident of November 20th, 2018, where, of course, at that point, unfortunately, SP was shot and killed. But the prior incidents were going back to 2017, where there was an altercation outside of Bookville High School at the stadium, where, and it's in the briefs. So I'm not going to go into long detail on that, but basically at that point, Prude took, SP took Devon's cell phone following this altercation with another person, refused to give it back, and showed that he had a gun, whereupon Devon left it alone. There was another indication or another incident outside of a drive-through in the summer of 2018 where SP yelled at him about the fact that he was going to come after him or he was going to tear him up. And I won't go into all the language that he used at that point that's in the record. And then in the fall of 2018, there was another incident where Devon Williams was kind of held up by another person, referred to as Big Baby. I won't use his name. Both are in the record. And he seemed like he was being held up, like, why are you holding me here, or why are you detaining me? It turned out he was detaining him because SP showed up, and at that point, it began to fight with Devon Williams and pistol whipped him. Now, I understand the state made a lot of, or put a lot of weight on the fact that there was no report of these incidents. Actually, that's not totally true because Devon Williams indicated that at the incident outside of Bookville, he did report that to a local police officer who was there for security purposes, but nothing came of that. And I know that the state has, argued about the fact that, well, we have these 3 incidences, but there's really not a lot of support for them. But at the same time, that is the evidence in the record. I don't think that they have to do anything more to support it. Devon Williams' testimony as to the events is sufficient to put that into the record, and that is clear in there, and no one rebutted it. Then we come to the events of November 20th, 2018. At that point, Devon Williams was at the Family Food Deli on South Arlington. He went into the store. While he is in the store, SP shows up in his Jeep and parks right in front of the front door. He's aware of this ongoing altercation, or they have had this history of this ongoing altercation. And I don't think there's any question that Devon Williams subjectively was scared about the events that could unfold, or the fact that he was felt subjectively in fear for his safety and his life. As a result, he went to the door. He had a gun on him. He did go to the door, apparently, and I think the surveillance shows it's a rather, and that was in the record, the surveillance video shows it's a rather small store. There's not really much room to hide or do anything else. He went to the front door. He crouched, or kind of moved around, crouched down, and the reason is because there's all of the, it's kind of like, what is it, signs in the windows blocking the view. But he opened the door, knew that he was out there from looking through, and he opened the door and he fired and discharged his firearm. While the state says that he seems to have aimed, take aim, shoot, take aim, shoot, it appears more that he just randomly shot until he emptied the clip in his gun, which appears to be 14 bullets that were fired. They found them scattered, 8 shots into the vehicle. Obviously, SP was shot also, and a companion that was with him had got out of the vehicle, the Jeep, and had fled. And there is an allegation that a couple shots were shot in his general direction, although that companion was not hit. I'm not going to...
Quick question. Was there testimony that Mr. Williams saw the victim with a gun in his hand or pointed towards them prior to shooting?
He testified that he saw the gun in SP's hands. He testified to that. Now, that is somewhat of a factual issue here. Understand, when the police came to the scene, they found the gun stuck between the seat and the console. So they saw the gun, and I understand it was the barrel end down, like you were holding the gun and you stuck it down in between the 2 seats. But we also know that the companion that was with them, I'll just identify him as LC, that was with SP prior to being shot, that when he's the one that got out of the vehicle, they actually had footage from his cell phone that showed that that SP had the gun in his lap as they were driving in the Jeep. So the idea that the police found it between the seat and the console after the events, doesn't negate the fact that there is evidence that SP had the gun in his lap, because that's what the cell phone footage of the other person that was in the vehicle, that LT, that's what that cell footage showed. So the only person who can say that I saw SP with the gun is Devon Williams, and he did. He testified that that's what he saw. He saw him come, the Jeep pulled up right to the front door. There is no manner of exit, all right, but that front door, and at least to the general public. And at that point, that's when he saw the gun, and he reacted.
Was there anybody else who testified? Another area that concerned me was there was testimony that your client smiled when he took the gun out. Was there, and I know your argument or on appeal was that he testified he smiles when he's afraid. Was that just the defendant's testimony, or was that established through other witnesses as well?
And what I would encourage you to do is look at the surveillance. There's some testimony from the surveillance video, or have one of the judicial attorneys look at the surveillance video, because I think it's really from the surveillance video that there at least is some accusation or statement made that he was smiling. That's questionable, all right? From looking at the surveillance camera, from looking at it, it's questionable as to whether you see that he's like, smiling in a gleeful manner, versus
Did your client deny that he was smiling?
Yeah, he never made any statement that he was smiling.
Okay.
Mr. James, you're now just getting into your rebuttal time. It's up to you if you want to keep going.
And Your Honor, I don't need the rebuttal. I'm sure that, I know that there was some, I filed a reply brief in this case, all right, to kind of correct some issues with regard to the facts and speculation on part of the state. What's important in this case is really to understand what is the level of threat that a person must endure. And this is unique because it's the first time that I think that this panel will be applying 2901.05. All right, and the issue is, what is the level of threat that I must perceive subjectively before I have the right to act in self-defense?
And to that end, Attorney James,
and this may be somewhat tickling.
Okay, it seems to be the foregone conclusion that SP was in pursuit of Mr. Williams into the store, but what's in the record about the timing, or whether that this isn't just a chance incident where SP shows up at the store at the same time? I understand that Mr. Williams' subjective information is that SP knew he was there and was coming into the store to get him, but what's in the record about what happened before, as Mr. Williams is entering the store, or anybody?
There's nothing in the record that I see that showed that SP was aware that Devon Williams was in the store and he was going there specifically for Devon Williams. All right, I have to be clear on that, but understand, given the history, the issue is subjectively from Devon Williams, what did he believe that SP was doing? He didn't know that he was showing up there randomly, or he was showing up there with a purpose to engage him. What's difficult in this case is to decide what, I'm sorry, and it's really a repeat, is what is the level of threat that one must endure?
But Mr. James, is that different? I mean, the law is different in the sense that the burden has certainly shifted and been put on the state, but the level of threat issue, isn't that really the same as it's always been? A reasonable subjective belief of imminent fear?
Right. No, I agree.
Okay. All right.
That standard has not changed. What's interesting in this, go ahead, have I used my time?
I was just going to ask my colleagues if they have any questions. You're fine.
Well, what would you, if there was a rule of law to come out of this case, what would it be, Attorney James?
I think some guidance, maybe for the entire community. That's really why I think this is kind of important, and guidance on the community as to what is actionable, what conduct is actionable in self-defense. How high must that threat become? How real must it become? There's no question that if SP had gotten out of his vehicle, he had a gun in his hand and was walking up to the door, we wouldn't question probably what Devon Williams did. The question at this point is that he's sitting in the vehicle right outside the front door and he has a gun. He has a gun, which surely there's evidence that he had it in his possession on his lap. And Devon Williams testified that he saw him with the gun. Understand we should all be in the same situation. If this was, and I have used this before, and I surely don't mean to minimize the risks that our police officers face, but if this was a police officer who had an ongoing dispute with a citizen, all right, and in those same situations, would the police officer possibly have said, look, this is my best course of action, I'm fearful here? I don't know. Understand, self-defense is very much subjective, but we are looking at that in response to what are the factors that go into that we use to go into play to justify self-defense, and
Okay.
that's where
Wrap up that sentence, because
this court can provide guidance as to what factors must we look for. That's what I was going to do, and just really some guidance on what are the threats that we must actually endure and perceive before we have a right to act in self-defense. And I will leave it at that.
Thank you very much, Mr. James.
Thank you.
All right, Attorney Corrigan.
Yes, ma'am. Good morning, and may it please the court. I'm Jacqueline Corrigan on behalf of the state. And just one thing I would like to bring up to the court's attention before I begin the bulk of my argument is that there is unfortunately a mistake at page 13 of the state's brief under the section that begins with the header of A, elements. Regarding the elements of the self-defense defense, there should be an and, or there should be an or rather than an and, linking the bona fide belief element and the duty to retreat element. That is an error, and I apologize for it, but these have to be disjunctive rather than conjunctive when it's the state's burden of proof, because each one of those elements must be present for the self-defense justification to apply, regardless of who bears the burden of proof. Now, getting to the rule of law that, or the guidance that Judge Teodosio was asking for, the state submits that the guidance that this court can give to all of the 4 counties within its purview is that a prior ongoing dispute between parties, regardless of whether it creates a subjective fear from between the parties, does not justify an ambush without any kind of objective cause from the victim. And I dispute with opposing counsel respectively that if this were a police officer, the police officer would also have been investigated and probably sued in this situation. But what is important to note is that even under the shifted burden of the changes to 290105, the state in this case did disprove each of the elements of self-defense beyond a reasonable doubt, and the jury did not lose its way in deciding that. Because
Can I ask you a question about that? You're talking about proving elements beyond a reasonable doubt or disproving elements beyond a reasonable doubt. And when I asked the question, one of the things that Attorney James said is about must prove each and every element, and I think we all agree with that. So I'll ask you the same thing. Is that a manifest weight review, or is that a sufficiency review? What are we to do here?
Well, the sufficiency review would be, did the state present evidence which, if a reasonable jury could believe it, when viewed in the light most favorable to the prosecution, could that support the verdict? With the manifest weight argument, you have to get into the credibility, and this court gets into the credibility of all of it. So it is a de novo review.
And would
So,
the sufficiency review be limited to the murder itself?
That's a good question, Your Honor. I hadn't thought of it that way, but the sufficiency would absolutely get into the murder. It may, I'd have to brief that, Your Honor, but my temptation, I know you don't, that's not an answer you really want to.
And I'm not trying to be tricky. I'm just generally trying to figure this out. But okay, go ahead. You could go on with your argument.
Okay. I'm tempted to question, as you are, whether sufficiency would actually apply to whether there was enough evidence presented to overcome or to combat information that would tend to show that the defendant acted in self-defense, which is what gives rise to the state's burden at this point. So I think this could be viewed on a sufficiency level. I think it possibly could be sufficiency. Manifest weight may be the best fit.
Fair enough.
So I think that may be where we're going.
Okay.
However, regardless, the jury didn't lose its way in this case, because what counsel and what Mr. Williams had forgotten about during the entire course of this case is that there really is no dispute that Mr. Williams had a subjective fear of the victim in this case. But what he lacked was an objective, bona fide belief that he was in imminent danger of grave harm from the victim at the point that he reached out the door with his gun and began firing. Okay? Because the case law, you have to remember, does not support the idea that a victim's acts in the past or an ongoing dispute between the victim and the defendant constitutes the affray or actually constitutes the objective component of the bona fide belief of grave harm. Okay? And for an example, I can point you to the case that this court recently decided, which was the Sheely case, in which this court was asked to decide whether there was sufficient evidence to justify giving a self-defense jury instruction. Now, that was under the prior standard, I believe, but this court decided that there wasn't. And that was a case where the victim had actually been attacked less than a few hours prior to the killing of the victim. So the victim had attacked the defendant. The defendant had returned with a group of friends to attack the defendant or attack the victim and get revenge, and had struck the victim with a brick, and then one of the friends then shot and killed the victim. And this court found that was not sufficient evidence of the defendant not creating the affray, and of the defendant having a bona fide belief that the victim was going to imminently cause him grave bodily harm to justify giving the self-defense instruction. So that's an illustration that this kind of ongoing past dispute between victim and defendant really does not create the affray, okay? And that in this case, the evidence is clear that Mr. Williams created the affray that occurred at that store at that time. The only thing the victim did was pull up, park the Jeep, did not even turn off the motor, did not turn off the windshield wipers, did not get out of the Jeep. Someone else in the store informed Mr. Williams that the victim was present. Mr. Williams looks out the window, sees the vehicle, smiles, racks it, pulls out his pistol, racks it, loading a bullet, grimaces, goes to the door, opens it a little bit, and starts firing. And he testified, by the way, that he aimed and fired each time.
Of course,
no matter how fast it was.
Counsel, didn't he also testify that he saw the victim with a gun and the passenger exited the vehicle and he believed that the passenger also had a gun, and the passenger walked towards the store.
That was his testimony, but in a manifest weight situation, I would also remind the court that that's where Mr. Williams's credibility comes into play. And the jury in this case found him to be less credible than the victim's companion, who had testified he didn't have a gun and that all he had done was exited the vehicle. And so the jury was in the best position to determine which one of those two testimonies was the most credible, and it decided that the companion's was the most credible.
Thank you.
So again, Mr. Williams created the affray. There was no participation by the victim in this incident other than to pull up into a parking space. And as far as the companion, again, the jury got to decide who was most credible. The companion did testify, and this gets to, Judge Titoza, this gets to one of your previous questions, that yes, he had recorded that the victim had, a gun in his lap while they were driving to the store, but the companion testified that he did not see the gun in the victim's hand at the time when he parked the Jeep and was preparing and the companion was preparing to leave the vehicle at the store. So also, though, because of all that, Mr. Williams also lacked an objectively reasonable bona fide belief that he was in imminent grave harm from the victim. Because again, nothing the victim did at the store would cause a reasonable person to believe that they were in imminent grave danger. And instead, Mr. Williams testified that he was acting proactively. He said, he testified that he was going, this is his direct quote, "I can't let them get out and try to kill me." So he was going to shoot first. And Your Honors, that's not something that I'm going to shoot them before they have the opportunity to even show me that they intend to do something to me is not what the law permits, except in one situation that is not present in this case. And that is where we have a battered woman syndrome, battered partner syndrome, or battered child syndrome case. Because otherwise, without those syndromes being present and without expert testimony to back those up, the law establishes that the mere presence of the victim is not an affray and does not establish an objectively reasonable fear of imminent death, and also does not negate the duty to retreat, okay? Because a non-confrontational killing just does not fit the definition of self-defense. And I can refer the court to the cases concerning battered women syndrome and battered child syndrome, such as State versus Nemeth and State versus Koss. So everything about this evidence shows that Mr. Williams, again, created the affray, did not have an objective, bona fide belief that he was in imminent danger of grave harm from the victim. And also, he also violated his duty to retreat because he had alternatives rather than to use deadly force against this victim. Just like the customer who testified that as soon as he saw Mr. Williams with the gun, he fled to the back of the store, okay? Mr. Williams could have done that. He could have called 911 and said, the person who's pistol whipped me, the person who has harassed me over the past couple of years or many years, he's here and I'm afraid that he's going to do something bad to me. Can you get a police officer here? He could have asked the owner of the store to call 911. He was across the counter from the owner. He could have said, hey, this is the person who pistol whipped me 3 months ago. Can you call 911? And also, can you lock the door to the store and prevent him from coming in? That was another way of avoiding the danger that he subjectively feared. Instead, What he did was he saw the Jeep pull in, he smiled, he loaded his gun, walked to the door. So he advanced toward the door and opened the door and began firing. Now, as far as that smile, I know Judge Teodosi, you had a question about that as well. There was no other testimony in the record that the defendant smiles when he's nervous. And in fact, the state pointed out in closing argument at page 910 of the transcript, during its closing argument, that the jury could recall observing Mr. Williams, and that while he was being cross-examined at a time when he would reasonably be nervous, he didn't smile. So the jury had that visual indication before it, although unfortunately nobody said, let the record reflect that the defendant is not smiling, even though we're cross-examining him. So under all that evidence, the jury didn't lose its way in finding that Mr. Williams did not act in self-defense, because the state did disprove each element of the defense beyond a reasonable doubt, even though by law it only really had to disprove one. And unless there are further questions from the court, the state would otherwise rely on its briefs.
Judge Hensel, any questions?
No, thank you.
Judge Teodosio, any questions?
Is it a factor at all when somebody receives a death threat and then is confronted with the person who made that threat? How much of a factor is that in this issue?
Well, that gets to the person's subjective belief of that they're going to be an imminent danger of great bodily harm. So far, the law does not permit the person to act proactively, except, like I said, in cases where you have an established battering situation and you have expert testimony to tell the jury why it would be reasonable for the person to believe that, even though there was no overt action by the victim to indicate that they were going to follow through on that threat that they had made in the past, why the victim would think that it was going to happen in the absence of that immediate threat, and also to establish why the victim would feel like they had no means of escaping the situation. So that's the only way that actually comes into play. Like I said, it gets to the mindset, specifically to the subjective component of the bona fide belief.
All right.
Judge Callahan, that was the only question I had.
Thank you. All right. Thank you both for your presentations. The court will take this matter under advisement. We will issue a written decision in due course. It'll be mailed to both sides, posted on our website and the website of the Supreme Court. Everybody take care, stay well, and